Hey guys, it's Kathy. I hope you're doing well. Still Friday for me, but happy Saturday. Friday was yesterday. I have to remind myself. Can't rely on Fozzie to remind me all the time what day it is. So I didn't put that video out because I was on Fleischer's stream the whole time and it went a little long. And then I didn't have any time. I would need to catch a little nap before work. So I'm gonna do it today. So weed makes this guy sue an entire town in Connecticut. He's suing the entire town. Now, I have to tell you, this isn't the trial or anything like that. This has been going on for 6 years. This and other lawsuits has been going on for like 6 years. And he had an attorney with him the whole time. Well, this is the hearing because the attorney is asking to withdraw from the case. He doesn't want his attorney to withdraw from the case. So the actual trial is set for November. So we just have to make sure we get to that trial in November. I'm I'm not sure if I can get the trial. I don't know what all they show in Connecticut. I think I can get the trial. I've had before. So I don't see any reason why they're going to put it in a place where I can't get to it this time. So you guys, man, my chat is already full. Do I have to scroll up? Is there any like questions for me? Somebody tell me. If I say it's Friday though, Carolyn will really get confused. Carolyn might miss work. Might miss work Monday because of me. Okay. We're going to start with that one. We're just going to start with that case. It's not long. It's just real good. I like it.
Okay, we're on the record, Your Honor.
Thank you.
Oh, it's
Please
so
open court hearing.
small.
Oi, 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 the Superior Court for the Judicial District of Waterbury at Waterbury for the transaction of civil business is now open and in session with place. All persons having cause or action pending or have been summoned or bound to appear herein and give their attention according to the law. The Honorable Carlitha Parkinson presiding.
Good morning, Your Honor.
Good morning.
Okay, thank you.
Oi, oi, oi. That's how we should greet each other from now on. Oi, oi, oi.
Okay, looks like we're all here. Court has been opened. Mr. Eccleston is still in the room. He already identified himself for the record. Would counsel now please identify for the record?
Bruce Newman for the plaintiff, Thomas Eccleston. Good morning.
Joseph Mingacci for the defendants.
Hey, good morning to everyone. I'm glad everyone is now in the right place. We're here today on a motion for permission to withdraw as counsel, which is at docket 147, filed on behalf of Attorney Newman and his firm. I've received the plaintiff's objection to that motion for permission to withdraw as counsel as well. Would you like to be heard, Attorney Newman?
Yes, Your Honor. First of all,
Don't talk to your boss. We don't like her.
I'd like to say that I do take my obligations of professional responsibility very seriously and to zealously represent my client within the bounds of the law through the term of my representation. That's why as of close of business yesterday, we did file some papers on his behalf just to continue to protect his interests in this matter. With that being said, I do want to also keep inviolate the attorney-client privilege, and I will note two things. One, Mr. Eccleston, in his objection, I believe concedes that the attorney-client privilege has broken down irretrievably, or attorney-client relationship, excuse me.
Right.
So I don't know if we need to get there, but I do have, a PDF document that I could submit to the court for in-camera review, which would make it patently clear why I can no longer represent Mr. Eccleston. Or otherwise, alternatively, bring it to the court. If the court wants me to bring it there, I could be there, but I have another hearing after this. It'd have to be like 2 o'clock. But I mean, I think I could, it's in PDF. I could send it to your clerk or to yourself, Your Honor, if you wish to see the emails. But that's really why I have to withdraw as counsel.
Yeah, I have to say, I remember this case. You argued a motion for summary judgment on this case a few months back. I remember this case, so I was surprised to see the motion to withdraw as counsel. I was surprised. Yeah.
So
Anything else?
I don't know if Attorney Mangachi would have any objection to me emailing that. It's just a snippet
hold
of
on.
it.
Well,
Yeah.
Hold on. I mean, the practice book says that, you know, once notice has been given to the client, unless good cause is shown as to why you shouldn't be given permission to withdraw. So let me hear from Mr. Eccleston.
Yes, Your
Hello,
Honor. Bruce has been an excellent attorney these last 6 years.
I'm glad
Bruce,
to hear that.
Yes, he's done an excellent job. And when I informed him of the May 16th FOIA discovery, Bruce was very excited about it and positive about it.
Before, Mr. Eccleston, before you say anything further, I want to just make sure you know that we are on the record. Everything you say is being recorded. You have an open case that is still pending, and the defense counsel for the other side is listening. So I just want to make sure that what we're hearing right now is your objection to Attorney Newman and his firm withdrawing as your counsel. This is not saying, we're not looking at the merits of your case right now. All right, and that's an important distinction. Do you understand the difference there?
I believe I do so, Your Honor.
Because I don't want you to say anything that you might later regret. And I'm not advising you, I'm just making sure you're fully informed of what we're doing here today.
Yes, Your Honor.
All right, proceed.
So Attorney Newman was positive about this information, and then after, I assume it was presented to the defendant, everything changed, and it was not a road he was eager to go down. And I believe that the defendant may have influenced his ability to represent me in my best interest.
So does that then, so what I have to look at as the judge looking at a motion for permission to withdraw as counsel,
Crazy.
I have to look at the grounds that Attorney Newman has presented to me seeking that permission. And he's saying that the attorney-client relationship has broken down irretrievably. It's like a marriage, right? It means there's no going back. There's no fixing it. There's no Band-Aid. There's no medicine that you can take that's gonna make you two come back together and be on the same page. And it kind of sounds like you're agreeing with that by saying that you have had a disagreement. Without going into what it is, right? It sounds like you had a disagreement.
I do not feel as though the attorney-client privilege broke down.
Not privilege, relationship.
Oh, yeah. Excuse me, the relationship. I do not believe it broke down. I have been extremely happy with Bruce Newman and his law firm's representation of this case. And I would like to keep Bruce Newman as my representative, Your Honor.
Anything else?
Sleep is for babies.
No, Your Honor.
Okay, Attorney Mangachi, do you take any position?
I have no objection to the motion. I think that it appears clear that the attorney-client relationship has broken down and most difficult for Attorney Newman to proceed.
What makes you come to that conclusion that the attorney-client relationship is
Yeah.
broken down?
How would you know, sir?
Well, as Attorney Newman pointed out, Mr. Eccleston himself admits that it is broken down. in his objection. The breakdown of the attorney-client relationship stems from a failure to act upon evidence provided,
What page is
culminating
that?
in threats received by his counsel. Yeah. So, I mean, to Attorney Newman's earlier point, it seems that Mr. Eccleston concedes there has been a breakdown in that relationship. And as Your Honor is well aware, I mean, as you made the analogy to the domestic situation, if you have a partnership of any kind and one side says it's broken down irretrievably, then it's broken down irretrievably.
Fozzie, it's broken
matter
down
what the other side
irretrievably.
says. And as pointed out, Mr. Newman has been involved in this case for a long time, including the federal court action, and has zealously represented his client. And if he's representing that he can no longer do that, then I certainly take him at his word, especially as a seasoned and experienced attorney.
Can someone just tell me, is that a bottle of pink hand lotion in front of him? Does he have like rose flavored hand lotion on the table in front of him?
Okay. You want to say something else? And Mr. Attorney Newman, of course, you get the last word. It's your motion. But if Mr. Eccleston wants to say something else, you certainly can, sir.
That's fine.
Yes, Your Honor. It sounded to me as though Attorney Mangachi made it sound like Bruce Newman gave me threats. That never happened. Threats of obstructing.
He was reading, so on page 1 of your objection under your statement, you've written your second paragraph, the breakdown of the attorney-client relationship stems from a failure to act upon evidence provided, culminating in threats received by my counsel. So I took that to mean somebody else is threatening your counsel.
Thank you, Your Honor.
That's what you wrote. Yeah, I got that. But what I think Attorney Mangachi's point is well taken, that you're admitting yourself that there is a breakdown. What you're disputing is what the cause of that breakdown is. Who's to blame for the breakdown, right? But you're admitting that there is a breakdown. And for me, unfortunately, I don't know that it matters the cause. It just matters that you and your attorney are no longer on the same page, or you're not seeing eye to eye, or you can no longer, the path forward, you're not aligned on what that is. And that's a problem. That's a problem.
I do believe we can get in line. I do believe that pursuing this new evidence is the way to go. And
the new evidence is why this is broken down. There's something crazy about this new evidence. And part of the new evidence is proof that the city is threatening his lawyer. But he's dying on this hill. He wants this new evidence in there. His attorney is telling him, dude, no, we're not doing this. This is not what we're going to do. So then there were some emails. Now, I have to tell you, they sealed the emails. I looked for them, but I saw the motion to seal the emails was granted. So we don't get to see the emails, unfortunately.
say at the end of my objection that it was my hope that an airing of these grievances would put things right. I feel I've been through this for 6 years and even prior to that with the defendant, and I am aware of the ability of some individuals to put others under their thumb and get them to do things they don't want to normally do. And I would hope that airing this events surrounding the May 16th acquisition would relieve Attorney Newman of some pressures he may have been feeling, either real or perceived.
So the reason he's feeling pressure is, here's what happened. Thomas Eccleston worked for the fire department as the fire chief, I believe, in Waterbury. And Thomas Eccleston asked for permission to get a medical marijuana card. No, he got a medical marijuana card. He didn't ask for permission. He got a medical marijuana card, and then he used marijuana. And then he got drug tested by the fire department, and they removed him as chief of police, fire, because he tested dirty. So they didn't fire him. They put him in a lower position. And it wasn't a good fit for him apparently, because then he got fired for using marijuana. Even though he showed them his medical marijuana card, they said, "No, we don't care. You are putting everybody at risk by using marijuana, to go fight fires. You just can't do that." So that's why he's suing everybody. But in his complaints and everything, he has these theories that, the mayor and everybody are out to get specifically him. And the city is pressuring and threatening his lawyer. And, he's been at this. He's been at this for a while. Not only that, I think he has another case. I'm going to look real quick. He has another case against another city. It is unemployment compensation. He has he's suing unemployment for this as well. So he has a couple cases going on.
I do not think the attorney-client relationship broke down. I believe this is no more than a hiccup, Your Honor.
Thank you, Mr. Eccleston. Attorney Newman.
As I mentioned at the outset, there certain emails were sent to me by Mr. Eccleston, and if the court would like to see those in camera, I could provide them in camera. Based on those, I don't believe I can continue. As I said, I don't think I can continue to represent Mr. Eccleston in this matter.
Because of what was said in the emails?
Yes.
I see. Okay. Has Attorney Mengachi seen those emails?
No, because I don't want to.
They're attorney-client privilege.
Right. So I don't
Mr.
only submit them in camera.
Understood. Mr. Eccleston, do you know, without telling me what's in the emails, do you know what emails Attorney Newman is referencing?
Yes, I believe I do.
And if I see those emails, right, do you think I'm going to think that your relationship has broken down?
I don't believe so, Your Honor, given the surrounding circumstances.
Okay, does anyone else want to say anything else?
Not at this time.
All right.
No,
It
Your
sounds like it does sound like I need to see the emails. They will be provided in camera. Madam Clerk, can we have some form of arrangement to make sure that those emails in hard copy come
Top
to
of the
me and
morning
I'm not
to you,
copying
Shannon.
onto Edison?
Yeah, if the attorney wants to mail them in, as we typically get them, or drop them off.
To your attention?
Yeah, that's fine, and I can give them to you.
Attorney Newman, you mentioned 2:00 today. Would you be able to bring them today?
Yes.
Okay.
Thank you so much.
Perhaps you can
Smoke
even
screen.
ask for
Yep.
the clerk, just to make sure, because I don't want them to get docketed.
I could email them to the clerk now too, but if it's easier to drop off, if you'd rather have me do it that way, that's fine, whichever the court prefers. And we
I
can
think
have,
hard copies probably better, because even with an email, there's still a record,
okay, that's fine.
Yeah.
So they should go in an envelope to your clerk. What's your clerk's name again? I'm sorry, I saw it quickly on the screen.
It's Sabrina Ahmed, just under the clerk's office, and I'll get them.
The clerk's office or case flow?
Clerk's office.
It sounds like I would want Sabrina Ahmed to be my lawyer. She sounds very confident.
Oh, I got your name now. Ahmed. Got it, Sabrina.
All right,
Okay.
thank you.
Sure.
All right, so I'll reserve decision until I've looked at the in-camera evidence that Attorney Newman is going to submit today, and then I'll issue an order.
And
Anything
I'm
else?
fine. Okay, that's fine.
Anything else that anyone wants to say on this issue?
Yes, Your Honor. If Your Honor does grant the motion, can the order include the fact that Mr. Eccleston needs to file an appearance on the record so we have some individual with whom to communicate on the case until he retains other counsel?
Fair enough. Is there a trial date?
Yes, Your Honor.
November
All right.
5th, I believe.
All right, very well. It says selecting jury November 7th with a TMC before Judge Cordani on 10/22. All right, very well. Thank you.
Maybe
Thank you for bringing
if
that
you're
to my
fighting a
attention,
fire,
Attorney Mangachi.
yeah,
Anything
Thank
else?
you, Your Honor.
Anything else?
Nothing from the
definitely
defense.
if you
All right.
started the fire.
Thank you all. I wish you all the best day. Thank you.
Thank you.
Thank
What
you.
is
Thank
adjourned?
you.
All right, court is now adjourned.
Oi, oi, oi. Oi, 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 court is now adjourned. So I looked, and not surprising to anybody here, the order for the attorney to withdraw has been granted. And he is now his own lawyer. And now he has to go find another lawyer that will take this case. And apparently that's, I mean, from what I just heard, it's going to be difficult. The emails they showed on camera, and I don't think he had dropped them off for them to get in yet. But we're not going to be able to look at them. There's a whole bunch of orders sealing them. Order. So we'll never know what happened with the crazy emails unless there's a way that the defense team can, offer some of that information during the trial. It could happen. It could be like, look, this guy is so crazy. This is what he said to his own lawyer. So fingers crossed, guys. Fingers crossed. Oi, oi, oi. We're just going to keep an eye on that until November. See if another attorney comes in. We're just going to keep an eye on it. So, all right, I included this just because I know I have a lot of people from Georgia that watch the stream. And apparently this was a big deal in Georgia. Maybe legal fiction will know. I don't know. I mean, things that are a big deal in Lancaster, I don't always know about. So, but I don't know if it is or not. So in case we have, people from Georgia watching, I got you. I got your back.
We'll handle this first.
Yes.
Okay, Your Honor, Mr. Worland is in jail, I believe, for robbery.
Threatening and intimidate an elderly person and robbery.
Bond was set by the magistrate at $25,000 cash, $50,000 property.
2550.
Sir?
I couldn't understand what you said.
25,000 cash, 50,000 property.
Okay.
Tree Fitty.
He's 24 years old. He's from Reedsville. He's unable to make bond currently set. He's been in jail for, I lost my notes.
Rosie, do you have this file?
Worland? He's been in jail for 29 days, Your Honor. We're requesting the court cut the bond to 15,000 cash, 30,000 property.
Which is prior record.
I'm looking, Your Honor. Hold on just a second. My files keep walking off from me. I'm not really sure. Oh, it's this one? This one? Sorry.
She has great red shoes on and you can't see them.
Is Mr. Minor's file in that stack?
Has a 2017 giving false name to a law enforcement
Thank you.
officer. And then a couple probation violations. He has a 2019 misdemeanor theft by conversion, 3 counts, also out of Reedsville. And he has a, let's see, amended DUI or DUI actually in 2022, and possession or use of drug-related objects out of Tattnall County State Court. He has a driving while license suspended in June of 2023, also out of Tattnall County. And then these charges here for robbery and threatening to intimidate.
Is that 1 or 2 felonies? Or one of those or 2 of those felonies? Some of them were misdemeanors.
None of those were felonies.
None of those are felonies, okay.
Oh, Your Honor, I believe this is his first felony charge. This is the one that was all over Facebook. The victim is 84 years old. He was robbed out in the county. This is the case that I'm talking about. Okay. This occurred in, I believe, June the 14th. It was the victim, 2 suspects wearing hoods and black clothing. And actually, I believe the community kind of came together rather quickly to ensure that this individual or individuals were located and put into custody. I remember seeing the Facebook post from the sheriff's office.
I watched the whole docket.
Saying that's a pretty low bond for robbery and intimidation of an elderly person. I'm going to leave it where the magistrate said it. The motion is denied.
Yes, Your Honor.
And I'll be right back.
Yeah, he's not going to lower the bond. Have you not ever met this man before? He is never going to lower that bond. There was another guy who came in front of him. And the lady in beige or white, she said she wanted the bond lowered because he's been in jail for a while. And it was like, I don't know, it was like a $10,000 bond. I don't remember exactly, but you guys don't know. So I'm going to say $10,000. Prove me wrong. It was a $10,000 bond. And the judge looks at it and he says, you know, who set this bond? Which judge set this bond? You're lucky. I would never give you a $10,000 bond. That was a $50,000 bond right there. Get out of here. We do have one more case from him, so let's look at it. It's way better than that one. But I just wanted to make sure. That seemed like a high-profile case in Georgia, and it was only a couple of minutes long. So now you guys can... Hey! Someone else in Texas just got their electricity back. That's awesome. Every time you hit like on Judge Fleischer's stream, someone in Texas gets electricity back. All right, here he is. I gotta love this judge. I just really do.
All right. Have we had a drug test done today?
No, sir.
Not, Your
Okay.
Honor.
Mr. Haran, what am I going to find out if I have a drug test done today?
What, Your Honor?
If I get the DCS to pull a drug screen today, am I going to find marijuana? Am I going to find Delta 8? Am I going to find alcohol? I'm going to find, what am I going to find?
You may find a little bit of alcohol and there may be marijuana
Okay.
in my system as well.
All right. They're asking me to allow you to go into an early intervention program to try to perhaps avoid a felony conviction
Yes, sir.
and avoid what would be, listen to these words very carefully, and to try to avoid what would be a mandatory prison sentence. Let those words sink in. Mandatory prison sentence. which means that if we are required to bring these charges back and to process you through the system, either you plead guilty and you're going to go to prison, mandatory court. Even I don't have any discretion over a part of that.
I understand.
Or if you go to trial, and if you're convicted at trial, it's going to be mandatory prison sentence. Now, early intervention means that you have to follow certain rules, do things that you're supposed to do, and not do things that you are not supposed to do. You're going to have to report to the early intervention officer. You're going to have to maintain your job. You're going to have to do those sorts of things. Those are easy. You're going to also have to avoid alcohol. And by avoid, I mean no alcohol use. How old are you?
18.
18. You're not supposed to be drinking alcohol anyway. Your brain's not through forming.
That's right.
And no marijuana, no cocaine, no meth, no any of that stuff. Now, probably I don't know if you've gotten up to the cocaine and meth yet or not, but marijuana seems to be pretty common. Now, you may say it's legal in Iowa and it's legal in Washington, or maybe it's legal in California, but it's not legal in Georgia. I don't think it's legal in South Carolina where you live.
No, Your Honor, it's not.
Now, through legislation which I cannot fathom or change, the law of Georgia and other states have created a quagmire where, well, okay, marijuana's not legal, but hemp is, and marijuana's not legal, but you can buy gummies with whatever it is. What are the words, the letters they use for that? It's got the letters.
Delta 8.
CBD.
And then you got Delta 8s and Delta 10s and all that. Everybody that's on probation and they get tested positive for marijuana, they want, whoa, I didn't use any marijuana. It was Delta 8. And you know what my answer to that is? I don't care. I do not want a positive test, period. Delta 8, Delta 10, CBD, that's what I was trying to look for. CBD, gummies, brownies that somebody else made and put marijuana in. I don't care where it came from. You're getting, this is not December 25th, but you're getting a Christmas present here today. That lady over there might as well be dressed up in a red suit and have a white beard. So she's giving you a Christmas present in July.
Thank you.
And you either going to honor it or you're going to be in prison. So 30 days, you're going to come back from now. I expect there to be no marijuana in your system. I expect there to be no alcohol in your system. I expect there to be no violations. I expect you to have done everything you're supposed to have done and nothing you aren't supposed to do. You can't step on the crack or spit on the sidewalk. Bottom line, you have got to stay straight, clean, and sober. And like I said, there's stuff in the stores, behind the counter in the convenience stores, that top shelf back there got all kind of stuff that can cause bedlam. Kratom. I don't even know what kratom is, but I know it comes in some of those substances. Energy drinks, they've got stuff in them. Don't drink the energy drinks. Don't all that little cans of things you see back behind the counter and all that. Drink water or Gatorade or Coca-Cola or something that you know is legitimate, iced tea that your mama makes at home. Leave all that other stuff alone. Just leave it alone, because they put stuff in it on purpose to get you to want another one. It's called addiction. They want you to be addicted to it. Believe it or not, Coca-Cola, when it first came out, had cocaine in it. And that's part of the reason it got so popular. It was good to people. You can't stand, it's no longer got that, by the way.
Yeah, I heard that.
Yeah, so it's no longer got that, but you cannot stand to mess this chance up. Because literally, I mean, this is what you've done here is, and your lawyer, I hope he'll tell you, I was reluctant to even accept this proposal. And because I'm reluctant to accept it, and because it is such a gift to you, it's not going to be pretty if you come back and you're not doing what you're supposed to do.
I understand.
It's not going to be pretty. It's going to be ugly. Because prison is ugly. It's not a place you want to be. But when you drive a motor vehicle at 100 miles an hour, that's bad enough. That's bad, okay? Truth be known, most of us when we were 18, 17, we drove faster than we were supposed to drive. We took chances and all that. Like I told your lawyer, when the red light came on back in those days of state patrol and the sheriff's deputies had red lights, they didn't have blue lights. Back in those days when the red lights came on, we stopped. We took our medicine. We didn't try to flee from the police. That's where this got more serious. That's where this got into the real danger zone, is when you're trying to flee from the police. People die every day from people who are fleeing from the police. Sometimes it's the person fleeing. Sometimes it's the officer. Sometimes it's a family in the family SUV on their way to church or Sunday school. And they get hit. The baby gets killed or mama gets killed. That's where this gets dangerous, is when you flee from the police. Which is why I was reluctant to accept this to begin with, and which is why it's going to be hard if you come back and don't make the best of this gift that you're being given. It's an old saying, to whom much is given, much is expected.
Spider-Man.
I'm expecting more of you than I would most other people in this position, because you have been given much. Okay?
Yes, Your Honor.
Like I say, no vapes, no energy drink. It's not going to be any excuse for any, if you go to a party, somebody's got punch, and you don't know what's in it, you better not drink it.
No.
You go to a party, somebody's got brownies, and everybody says, oh, these make you feel good. You better not eat them. And I'm not being facetious. I've had people come to court who got high on marijuana on brownies that somebody else made. If you don't know what it is and where it came from and what's in it, do not put it in your mouth.
I understand.
You got it?
Yes.
Any questions?
That's good advice, guys.
No, not at the moment.
All right. Do you believe I'll send you to prison in a heartbeat if you come back here and you're not violating, and you're violating these rules?
Oh yeah, I was scared coming today.
So if you don't, you've been here long enough to know that'll happen, haven't you?
Yeah.
Okay. And your lawyer can tell you. He's known me 30 years, probably at least.
Yes.
All right. Thank you, sir.
Thank you, Your Honor.
Your Honor, if you would sign that.
I will.
Come back order.
Bless his heart, guys. Bless that judge's heart. I love that judge. He has the best little sayings, and he just uses them all the time. Speaking of the best sayings that are used all the time, it's time for Fleischer. So I skipped the whole beginning and started from the middle of the docket because I didn't want to hear any comments like I did this morning. So I just started from the middle where it was nice and safe. But, there's more stuff on his channel. His stream was 4 hours today. So feel free to go over and watch. I'm obviously gonna play more of today's docket tomorrow, or wait, I don't know what day it is, the next 2 days, because he's not in court. And yesterday's docket, I'm gonna do that too. I think I have more too, because I took off a day this week. So I have a whole nother docket that I need to try to fit in here. So we'll see what I missed. Maybe we'll see. Oh, you did that while I was talking, Carolyn. I don't really see chat when I'm talking because you guys distract me. See, I got distracted. Here we go. Here comes Fleischer.
I'll call the cases of the people of the state of California.
Thank you, Fozzie.
Versus Deidre Joyner. She's here with Ms. Peak. Her case number is CR 24006696.
That does not look like Fleischer,
Also
does it?
present is Raymond Michael Miranda. Mr. Miranda is here with Ms. Lee. His case number is...
I had one more clip for today. I forgot. We did Georgia. We did Connecticut. Now we're going to go the whole way to California before we come back to Texas. So this is California. This judge, she's almost the complete opposite of the last judge. The last judge talks about mom's iced tea. This judge talks about the law. The law.
CR 24006694. Ms. Russell is here for the people. The case is on today for a no time waiver, preliminary hearing with a 1 hour time estimate. I have no motion to continue in the file. Ms. Peak, what's the request?
Your Honor, I know that there is no request to continue motion before the court. However, it is my understanding that there is a global offer for not just the two defendants, but the two cases. As you may recall, I got the case on Monday. Tuesday, I received the discovery. Wednesday, I had an unexpected medical procedure that I had to have done. So I did prepare the first case. I did not prepare the second case. I've not had a chance.
Is this the second case?
This is the second case. I prepared the second case, not the first case. But in light of the fact that it is a global resolution, I do believe that we can resolve the matter. I just need to talk to my client in depth about both cases so that she understands the terms of the agreement, the defenses that we may have for the cases or for that first case. So I'm going to ask, I apologize, first of all, for not having filed a motion, but again, I was told today that it is a global resolution.
So the request to continue is based on there being an offer?
In part, yes.
That's not a good cause. How come we can't do the prelim as scheduled, and then if you all work it out at another date, you do that?
The offer would be off the table.
Then she can take it today.
But I have not had a chance to prepare that other case, Your Honor. It's been 4 days, really.
But you're prepared on this case?
To do a prelim, but the repercussions of having...
I think he was grumpy.
Make a determination on that second case means that she is facing a lot of time if we don't take the deal. And it's really an unprepared deal, I'm just not ready.
You're not ready to just have a disposition.
Exactly.
But what you're telling me is that you want me to vacate a prelim on the day of prelim because the people made an offer that she's not prepared to take.
And I do believe I did mention on Monday that we had hoped that both prelims could go on the same day, keep the cases together. And
how does that make it better? The offer would still be the same. Even if the two prelims were on today, how does that make it better for you?
If the two prelims had been on today, I would have prepared both prelims. I would have been able to have the conversations necessary with my client so we could make an informed decision as to that global resolution. The fact that the offer disappears puts my client at a severe disadvantage if I have one prelim today and another prelim at the end of the month.
I don't see how that's good cause to continue this prelim because the people don't want to hold an offer open.
I think that if we hold the prelim today, and if the court holds my client to answer, the people's position changes and thus the offer changes as well.
Ms. Russell, are you in a position today that's going to be different after the prelim?
Advoca.
I'm not entirely sure what the court's asking me. My offer was contingent on if the case is resolved globally, pre-prelim.
Both of them?
Yes.
And is this the first time you made the offer?
No.
It's not, so it's not a new offer.
To Ms. Peak, it was made this week when she got the case. But I think I'm not sure when she got the discovery. I asked for it when she was appointed this week. I can't speak to exactly when she got the discovery in the cases, but it's always been a global package offer to both defendants. But I do understand Ms. Peak's position in that she's just come in on these cases and may or may not have had enough time to review all of the discovery in the cases.
But why not leave the offer open if you understand that?
Because the offer has been, both defendants are looking at significant time. And
No, you know how Judge Fleischer in his stream chats in chat? There was one guy in Fleischer's chat today that would not believe, no matter what was said, that was Judge Fleischer talking in chat.
it was pre-prelim, the offer was extended, and it was explained that it was pre-prelim only for the offer that's being extended. So the people don't oppose vacating today's prelim.
I oppose vacating today's prelim unless there's a good reason to do it.
I'm not arguing with that, Your Honor. I'm just stating the people's position for the court. So I don't oppose given Ms. Peak's representations to the court. And I would be okay if the court's okay with setting them both on the 26th to give Ms. Peak time to review.
I didn't put them on the 26th together because I don't have sufficient time on the 26th for both.
Your Honor, I will also point out that I did receive videos, but the videos are not of my client. The videos are of the co-defendant. So because those videos exist, I suspect that there are videos of my client as well, and I have not received those. I don't know which.
So she doesn't have discovery, and she was only appointed 4 days ago, and she wants a continuance.
Which one of the two cases the videos pertain?
Are you presenting videos today?
No.
Ms. Peak, I know that you're just coming into this case, but I'm looking at the history of these cases, and I've already had 6 early case management conferences. These defendants have not waived time, and I have got to get their prelims done before 60 days expires. I can see the co-defendant shaking his head. We're both in custody. I can't vacate a prelim just because she's not prepared to take an offer that the people don't want to keep open. If the offer's open for her today, you can
And
speak
it's
to her over the lunch hour.
probably a good global package. It's probably a good
I'm not
offer.
sure why time wasn't waived. My client has indicated that she is willing to waive time.
I'm not sure either, but today's the day for prelim.
My notes show that both defendants waived time on the 3rd.
I'm showing that I have a 60th day on the 22nd, and today's the day for prelim. And I'm counting 6 prior early case management conferences. Now is the time for prelim. The time for negotiations is over because we've set a prelim.
And I would let the court know that it through no fault of my client
It's a bit sus that you're asking that, Kelly. Just sus.
has she gone through the different attorneys. It does appear that when at the last hearing, when the previous attorney was not able to resolve the case, a conflict was declared shortly thereafter. I don't believe that it, especially when my client's telling me that she was willing to waive time previously, that it is fair to her to have an attorney handle a case where I am expressing to you that it's putting her at a disadvantage if she's held to answer today.
I understand that. Every time you're held to answer, it puts you at a disadvantage.
But
I get that, but what is the court supposed to do? If I hold multiple early case management conferences and the parties aren't able to settle it, I reserve time on the court's calendar, we subpoena witnesses, and then just because there's an offer that's about to expire, we vacate the prelim and go back to talking. The people have to put the evidence on. If they don't want to settle, they don't have to, but I have to be prepared to give them a hearing. And the only way I can manage my calendar is if I reserve time and then use that time. I can't just set cases and then vacate the prelim when there's not good cause. The prelim needs to go forward today. If she doesn't want to resolve it, she doesn't want to resolve it. If people don't want to keep the offer open, they don't keep it open. That's part of negotiations. If there's an opportunity for her to discuss it with you over the lunch hour, she can do that. It's almost noon now. I've been on the bench all day on other matters. She could have been considering the offer then. I don't know what more the court can do to try to resolve these cases prior to getting in this situation.
I'll come back at 1:30, Judge.
All right, we'll have the prelim at 1:30.
I didn't get it when they came back, so I don't know what happened, but I do know that the judge was not having it. Didn't matter if everybody in that courtroom agreed. The judge said, nope, absolutely not. So yeah, Grumpy was at Judge Fleischer's court. I mean, you know how like sometimes Judge Fleischer texts in chat. Sometimes Judge Fleischer chats on his phone in chat. Well, when he's on his phone, you can't really see his phone. It's like under the camera. So like messages from Judge Fleischer were just appearing in the chat. And Grumpy was like, that's not the judge, blah, blah, blah. And I don't know why he was getting kind of like upset about it, like mad that it wasn't like no one agreed with him when we were all telling him, nope, that's the judge. Even the judge, I said to the judge, I said, Judge, Grumpy doesn't think it's you. And the judge replied to him. And then Grumpy was like, F that, and left. He left. But I don't know. Yeah, there is definitely a delay. Absolutely. And sometimes it is weird that, we'll see the judge turn around and then a message will pop up. But, I have no idea why that would make someone angry at all. I have no idea at what part of that would make someone angry. What is there to be angry about? Let's just say it's not the judge. Let's say Victoria's pretending to be the judge, which she does on Saturday nights. So that's why I knew it wasn't her, because it's not Saturday. It wasn't Saturday. Who cares? Really? Why would that make you angry? Why would you feel anger at that? I don't know. But he was grumpy. Yeah. He was confused. Open your eyes, Vince. Open your eyes. All right, now. I know I promised this before, and then I just didn't put him on. This is Judge Fleischer from earlier today in his Friday outfit, which, by the way, is not subdued. It's lovely. It's a lovely Friday outfit.
Hey, Vic, you say he has a lawyer?
And there may or may not be a surprise visit by Ramona and Will at the end.
Who? You don't know? Okay, don't worry about it.
Miss Aurora, Your Honor, I want to say topic 2.
Got it. Good morning, Miss Aurora. You're Reedy Aurora?
Yes.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On July 4th, 2024, officers were dispatched to a suspicious vehicle call While en route, the officer came across a vehicle accident. The officer observed the defendant was the sole occupant of a gray Toyota and observed her get out and noticed a strong odor of alcohol on the breath, and she was unable to provide an account of what happened. She was unsteady on her feet and unable to say where she was coming from, but was going to buy fireworks. When asked if she had consumed alcohol, the defendant denied drinking alcohol. The defendant refused standardized field sobriety testing. The defendant gave an incorrect Texas driver's license number, leaving off 2 digits. Officers read DIC, defendant refused breath, and a search warrant was executed and blood was taken. The other driver was cited for failure to yield and was at fault.
I will. I
Where
might
is
not
the
get it
stop?
on
Was
here
she
though.
stopped, or was she just in the middle of the road? I missed that.
It was
It was that, okay, got it. Ms. Aurora, I'm going to find that there's probable cause to go forward.
Did you guys all see that? Okay, hold on. Watch again. Here we go. I'm going to go back 10 seconds. Okay. This is the best part of the whole stream. Hands down.
What was the stop? Was she stopped, or was she
It's
just
right.
in the
It'll
middle of
be
the road?
right here.
I missed that.
See,
It was
see,
that, okay,
Victoria.
got it. Ms. Aurora, I'm going to find that there's probable cause to go forward with the case. Do you have a
Victoria waved to us, guys. That was for all us Vibers. She was saying hi, Vibers.
valid Texas driver license, ma'am?
Yes, sir.
Do you have valid liability insurance in your name? I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or drugs, you will go to jail. You will not get any more PR bonds. You understand? We're going to reset your case to give you time to hire a lawyer. So first, I'll have you go to Victoria, sign a reset. Eventually, you'll get retraced for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer.
Samir?
Judge, bottom of page 2, ASALO.
Sorry.
Bottom of 2, Your Honor.
Is it Mr. Asamoah? Mr. Asamoah, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On July 4th, 2024, officers conducted a traffic stop on a vehicle who ran a red light. They observed the driver to have red glossy eyes and the smell of marijuana. The defendant admitted to smoking marijuana and said that he left a pool party and was going to a liquor store to buy alcohol. Standard field sobriety test was conducted, 0 of 6 on the HGN, 5 of 8 on the walk and turn, and 3 of 4 on the one-leg stand. The officer was also a certified A-ride and conducted an A-ride test. He stimulated 30-second counts. Defendant correctly estimated 30 seconds, but swayed at 12. The defendant's eyes did not converge on the lack of convergence test. The modified Romberg, the defendant's eyelids trembled, and finger to nose, the defendant was unable to consistently touch the tip of his nose with the tip of his index finger, touching instead his upper lip and above his nose. The defendant stated he was a 3 or 4 out of 10, with 10 being completely high, and stated he would still be comfortable driving a school bus of kids in his seat. He was red. Blood warrant.
That's always a great thing to say to the officer. Look, officer, I'm a little high, but I can still drive a school bus of kids. That you'll get off every single time.
Blood work was executed and blood was drawn.
So they did the DRE then. Any prior DWIs?
No, no criminal history.
Mr. Asimo, how old are you, sir?
19.
What do you do for a living?
Right now, just trying to work to go to college.
Did you graduate high school?
I graduated.
Okay. It's time for you to do something. You either need to get a full-time job or get into school full-time. I'm not gonna let you be out here doing nothing all day, smoking weed and playing Xbox. Do you understand?
Sure.
I'm going to test you 30 days from today. You test positive for marijuana, what do you think is gonna happen? Right. As long as you stop smoking as starting today, you will be fine in 31 days. Or notice that you will get tested. That's it. There's no excuse. If you hang with dogs, you're gonna get fleas. I will not accept the excuse that, oh, I'm in a car and there's other people smoking dope and I didn't smoke. I don't care. I don't care where you're going, who you're with. You test positive, you're gonna stay with me. I will have you apply for an appointed lawyer today, Mr. Asama. And then what I'm gonna do is I'm gonna bring you back in 2 weeks. And I want you to show me what you have done to get a full-time job. If you've done nothing, life's not gonna go well for you.
That's facts.
You understand, sir? Okay. I am ordering you not to consume alcohol or illegal drugs. I will randomly test you. You test positive for alcohol. Likewise, I will put you in jail. You will not get any more PR bonds. That's it.
So,
Do you have a Texas driver license? You are not allowed to drive. You will be signing an affidavit with me today, promising me you're not going to drive. The worst possible thing you can do in this short life is get in a car and drive, because you do, you'll be facing a contempt hearing, up to 6 months in jail, and a $500 fine every time you drive. Okay, so do you mind giving an application, Deputy, please, for an appointed lawyer? So first, we get 2 weeks back, and then another 2 weeks after that to come and take a drug test. And then I'll make a notation now so we don't forget.
Judge, page 3. Bruno, come on up.
Atari will always be cool. Always. I didn't even think about that, but now that you say it, yep, it does.
Okay, what is your name, sir?
Page 3, Bruno.
Mr. Bruno, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
On July 5th, 2024, officers conducted a traffic stop on a motor vehicle for failure to signal lane changes 2 times and an expired registration from February 2019. The defendant was a driver and sole occupant and was ID'd by his Texas identification card. Officers observed the smell of marijuana, and a probable cause search turned up 2.6 grams of marijuana in the front passenger seat and 6.4 grams and 6.5 grams in two separate bags in his hand Louis Vuitton fanny pack.
Mr. Bruno, I'm going to find that there's probable cause. Do you have a valid Texas driver license?
Suspended at the time.
Okay, you're not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. I don't care what you have to do, where you got to go. If you don't have a license and insurance, do not drive. Otherwise, you'll be facing 6 months in jail every time you drive. If you want to drive, go get a license, liability insurance, and then we can talk. But until that point, you drive, you're mine. You understand?
It's a good point. But what about the rest of the year? So I was watching chat today in his courtroom, and a lot of people were saying his jacket is blue. And the rest of us normal people were saying it's purple. What color do you think his jacket is?
We are going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. After that, I'm going to get you to Victoria. I'm not putting any conditions on you, Mr. Bruno. The only thing I'm asking you to do is don't drive and don't get in trouble. If you pick up a new case, or I really, really hope you don't drive, because if you do, I'm really going to lose it. So don't drive. I hope you heed this warning. Do you understand? A lot of people don't think it's a big deal, but I do. And I put a lot of people in jail because of it. So heed this warning. You won't get another one. I have you come up here, swear to us you're not going to drive. I'll get you to Victoria and we'll get you out here. When you come back, please have a lawyer.
Page 4, Shannon.
Brent, do you have an arraignment? I do. Okay, well, Victoria, Brent has an arraignment. Brent. Oh, Spanish speaker? Okay, come on.
Page 7.
And next time, just come up so you don't have to wait.
I didn't want
Come on.
to.
What's the last name?
Gardunio, G-A-R-D-U-N-O.
Page 7.
All right. Yes. Good morning, sir. Sir, you're charged of driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 5th, 2024, Metro Police responded to a traffic collision between a bus and a car. The officer met with the bus driver who said she was out of service driving on I-45 when she heard the screeching of tires and felt as if something hit the bus and noticed a vehicle spinning out of control. Officers went to search for the car on I-45 with no results. However, HPD was talking with 3 drivers on Houston Avenue involved in the traffic collision. HPD advised that they detained the defendant and that he was the driver of the car that struck the bus. Wheel witness said he observed the defendant pass him at a high rate of speed, switch lanes to go around the bus, and lose control. The wheel witness swerved out of the way, causing another accident. The defendant was observed to have a strong odor of alcohol on the breath, red bloodshot eyes, and slurred speech. Standard field sobriety test was conducted. HGN was a 6 of 6, walk and turn was a 5 of 8, and one leg stand was a 3 of 4. The IC was red and breath was a .168 and a .170.
Okay. Any priority to be honest?
No, Your Honor.
Okay. Mr. Gardunio, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, sir?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir.
Are you sure?
Yes, sir.
Okay.
I asked some of that earlier, Judge.
Because there's a lot of accidents that happen here. They're going to come after who? Right. So I hope you did have insurance. Now, I am ordering you as a condition of your bond not to consume alcohol illegal drugs or unprescribed controlled medication, I'm going to randomly test you.
I didn't
If I
even
find
think
that
of that.
consuming alcohol or drugs, you will go to one place. Do you understand?
Yes, sir.
Where would you go?
Jail.
Right. Don't drink, don't use any illegal substances. You understand?
Yes.
You must also stay in touch with Mr. Washington. He will tell you if and when you have to come back to court. If he tells me that you're playing games, that you're not responding to phone calls or text messages, I will issue a warrant for your arrest. You understand what's expected of you? Yes. Don't pick up any new cases, and if your license gets suspended, do not drive. I'll have you go to Victoria, sign a reset. After that, you'll get traced your bond conditions, and then you're free to go, sir. Right.
Thank you,
Thanks.
Judge. Appreciate it.
Thank you.
Good morning, Your Honor, may I approach?
Sure.
I'm here on Mr. Padilla Pearl, Your Honor. I had your clerk print out an informative notice.
Let me just finish with the arraignments real quick.
Okay,
And then
oh,
I'll
I'm
finish
sorry,
up.
I thought you were done, Your Honor. I stepped out for a
No.
second. My mistake. May I excuse, Judge? Everybody in the middle.
We still have a good amount.
Yeah, that's fine.
Today, so.
No, that's okay, Judge. Thank you.
Cameron is our next one.
Page
Okay.
4, Cannon, come on up.
TVs have more settings for their color. Some people watch it in movie and light and dark. So yeah, it could be really blue on their TV.
Court again, Miss Cannon. What do you think is going to happen? Right. This time, you will have a very hefty and large bond amount that you will be required to foot because you will not get any more PR bonds. Do you understand, ma'am? Okay. What are you doing about a lawyer? What are you doing about a lawyer, ma'am? What are you doing about a lawyer? What do you do for a living?
I work in security.
Okay, how much money do you make a month? You have to qualify for an appointed lawyer. We don't just give them out like it's candy, right? You have to qualify. You told us something differently on a different affidavit, man.
No,
Okay, ma'am, just go ahead and take a seat for me in the jury box. You reach out to the man.
Next judge is page 5, Davis, come on up.
Good morning, Mr. Davis. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Boyfriend of the defendant were on their way back when the defendant began recklessly driving, causing the complaining witness to fear for his safety. This led to the complaining witness and the defendant having a verbal argument, which escalated as they got home. The complaining witness told the defendant to pack his things and leave, then locked himself in the bathroom to keep them separate. The defendant kicked down the bathroom door and began striking him all across his upper torso, face, and head with both open and closed fists, yelling how the complaining witness shouldn't have told him to leave the house. The complaining witness stated the defendant's assault was putting him in fear of his safety and causing him pain, so he pushed past him and ran out of the unit. The defendant followed the complaining witness and continued to strike him across the back before biting him across the middle section of his back, causing pain. The complaining witness then ran away and called the police. The complaining witness arrived shortly after to find the defendant was gone and walked into the unit, locking the front door. The defendant kicked down the front door after a few minutes, to which police arrived, and the complaining witness had 2 knocks on the right side of his head that were actively bleeding and a fresh bite mark that did not break skin, along with defensive wounds across both hands.
Guys, don't bite. I know that your mamas and your dads all told you, don't bite. Just don't bite.
Mr. Davis, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. You understand? I'm also ordering you not to be in possession of weapons. There's a protective order that's been issued in this case. I suggest you get to know it, because if you do something to violate the protective order, the state can and will file a violation of a protective order against you. It's one of the worst cases you can pick up. If you violate those conditions, I can hold you at no bond. 0 bond until this case is over with, and I will do it in a heartbeat to protect every person in Harris County. Do you understand? So this MOA has a portion that's struck out for the no contact. I'd like to put it back in though. Should we issue a new MOA? Okay, I'd like to do that, please. All right, Mr. Davis, we're going to reset your case to give you time to hire a lawyer. So I'm first going to have you go to Victoria, sign and reset. After that, I will have you take your seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. No contact. Do you understand? Okay.
Your Honor, with regards to the bond conditions, I just filed no contact.
Please, and no weapons. Yeah. Okay, come on.
All right, Judge, page 8, Gonzalez, Era, come on up.
I don't know if Filthy Animal is on today, but if he's not, he'll be on tomorrow. Don't worry.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On July 5th, 2024, officers were dispatched to a medical emergency involving an intoxicated driver at Barker, Cypress, and Clay Road. Upon arrival, officers observed a vehicle stationary at the light and remained stationary while the light cycled. Officers walked up to the driver's side and made contact with the driver and sole occupant, who was unconscious. The vehicle was running and his foot was on the brake. Officers then woke the defendant up, and the defendant put the vehicle in park and he exited the vehicle. Officers observed a strong odor of alcohol on the breath, red glossy eyes, and the defendant said he was on his way home from a house party. Standard field sobriety test was conducted, 6 of 6 on the HGN, 3 of 8 on the walk and turn, and 2 of 4 on the one-leg stand. DIC was read, and breath was a .125 and a .129. The defendant was ID'd by his Florida driver's license.
Any priority to the eyes?
No, Your Honor, no criminal history.
Sir, I'm going to find that there's probable cause to go forward with the case. Tell me, do you live in Harris County now, or do you live in Florida?
Yeah, I'll be kind of back and forward.
What's the home base?
Houston.
Okay, it's time for you to surrender your Florida license and get a Texas driver license. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, you will go to jail. We're going to reset your case to give you time to hire a lawyer. So first, I'm going to have you go to Victoria, sign a reset. You will then get with Chase for your bond conditions, and then you'll be free to go. If you like your license, get on it quick. You need to find a lawyer quick. You understand? Come on. What?
Johnson, Armand, come on up, please. Page 10, Johnson.
Fozzie, I hate to tell you you're
Miss-
wrong, but
Miss
I'm gonna
Johnson?
show you
Good
later.
morning, Miss Johnson. But didn't we just have Miss Johnson here?
She came in late last time and we told her to come back for the arraignment.
Oh, okay. Can we just go ahead and give her an application now? Okay, we're gonna give you an application for an appointed lawyer, ma'am. Ma'am, it's not the end of the world. Just fill it out. We'll have you talk with someone today, okay? I think we did find PC on this, all right? We found PC on this one already, didn't we? This is Johnson.
Just for this one, we didn't formally,
We did, yeah.
The note I have on it is that she appeared and you reset for Monday so that we can appoint an attorney and the bond was reinstated.
Guys ready for the next one? Ready with that? Page 10, Johnson, Nicholas.
Take a seat for me in the jury box. Take a seat for me in the jury box. Who's next?
Judge, the next one is page 15. Dexter.
It's not a controversy at all.
My deck show. Good morning, Mr. Madexo. You're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain
Me
silent. They can or will use against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On June 30th, 2024, officers responded to an intoxicated person call for service where the defendant was taken into custody for public intoxication. While the defendant was being transported, he became belligerent in the backseat of the marked patrol unit by screaming and kicking his feet against the partition. The defendant proceeded with erratic behavior and slammed his head against the partition, causing a laceration on his forehead. The officers removed the defendant from the backseat of the patrol unit to help prevent further self-harm, and the defendant, who was placed on the ground, proceeded to actively resist arrest by repeatedly kicking his feet and rocking his body side to side, making it difficult for officers to control. During that time, one of the officers performed a wrist lock technique in an attempt to control the defendant. The defendant continued to resist, causing injury to the right ring finger of the officer as it got trapped between the defendant and the ground. An additional assisting unit arrived and police were able to restrain the defendant.
Sir, I'm going to find that there's probable cause to go forward with your case. You know, you have a lot of priors. I wonder how many of those priors are related to just that very fact of alcohol and or dope, you know? You know, there are some people, when they get lit, they become happy like little bunnies jumping in the woods. And then there are those that turn into what? Right. Got to be careful, man. Life's way too short. Just
2 more days, no, that I would have been in rehab. I was already volunteering to go into rehab, so I can have housing.
It's always a shoulda,
I
coulda,
start
woulda.
my job Monday.
Now is the time, though, Mr. Madek Show. It's gonna happen now. No more alcohol, no more dope. Do you still want to do that?
Yes, sir. Yes, sir. It's in court. It's in the report.
I want to see it happen. And
Yes,
we're
sir.
gonna either do it your way or we're gonna do it my way. And I promise you, you're not gonna like the way that I do it.
I
I will
went to-
give you the one opportunity to do it yourself. And I'm gonna tell you now, if it doesn't happen, we're gonna do it my way. You're not gonna like my way. You understand? I'm gonna give you a lawyer today, and we will work out how we're gonna do the logistics today. No more alcohol, no more dope. You understand, sir? Now, I don't think he's on probation, right? Did he get early terminated from that probation? I'm showing he's on deferred for burglary of the building, but I think he may have
That was
gotten,
terminated, Judge.
okay, it's a lucky thing.
I don't know why it stays on there like that.
The problem is that the more you get into trouble with law enforcement, the more they're gonna harass you and harangue you about it. You know what I mean? So look, I'm gonna give you a lawyer today. Let's figure out how we're gonna go from here. No more alcohol, no more.
Who else thought he was going to slam his head right there?
Don't even worry about it.
Okay.
Let's just, I'm gonna have you first go to Victoria, sign a reset, and then I'm gonna have you take you to the jury box while I find you something, okay? All right.
Judge, was that the next one?
No, monitor, yeah.
All right, Judge, the next arraignment is page 20. Regine.
Is it Prejean or Prejean? Prejean. Prejean. Mr. Prejean, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present, or you cannot afford one. One will be appointed to you, sir.
On July 6, 2024, officers conducted a traffic stop on a vehicle for defective left rear stop plan. Upon
Reset. I think it's their next court date.
making contact with the driver, they observed a strong odor of marijuana emanating from the car and ID'd the driver by his Texas identification card as the defendant. Officers observed a large plastic bag in the center console containing marijuana. Improbable cause search discovered 3 additional bags of marijuana. The total weight was 3.95 ounces of marijuana.
Sir, I'm gonna find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
No, sir.
You are not allowed to drive. You will be signing an affidavit with me today, Mr. Prejean. If I find that you drive, I will have a contempt hearing. You'll be facing 6 months in jail and a $500 fine every time you drive. Do you understand? If you want to drive, go get a license and insurance. Other than that, if you drive, you're mine. You understand? I'm gonna have you come up here, swear to us that you're not gonna drive. I will get you to Victoria. We'll have you sign a receipt. And we'll get you out of here. When you come back, please have a lawyer.
Sir, do not outburst in this courtroom.
Stop.
Page 22 and 23, Robbins, Ashley. Page 24, Stager,
Vic,
come on up.
Victoria, who's this?
Oh, yeah. Okay, page 22, 23, Robbins.
Okay.
You done did. Done did, Donald.
Are you Ashley Robbins?
Yes.
Ms. Robbins, you are now charged with yet another case.
Predates the prior office.
How many times she missed court here? Connor, come on up.
Hey, Judge.
I know she's your client, right?
Yes, on the older case, yes. So,
She just missed once on June 5th.
so what happened, Judge, is there was a complaint filed recently about a case that was 2 years ago. And then on that day, we reset her to get her here, and she was unable to make it on that day. And then she forfeited, and then she got rearrested, and then we're here today.
So the possession case was from April. And then right after that one, she picks up a burglary of a motor vehicle.
The DMV is from 2022, but the complaint wasn't filed until one day until the statute of limitations ran. Yes.
Yeah, you're right. Have we found probable cause on it? Do you know?
I don't think so, Judge.
Okay, so Ms. Robbins, you're charged with 2 cases. You're charged with burglary of a motor vehicle. You're also charged with possession of controlled substance. You're facing a year in jail and or a $4,000 fine on both of those cases. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. So I guess start with the burglary case if you don't mind.
Officers conducted a follow-up investigation and found that on May 23rd, 2024, the defendant had been identified as entering the complaining witness's car without her consent. The officers spoke with the business owner, who provided a video and photos of the incident, which were then matched with the defendant's Facebook photos, which was provided by the complaining witness. The video showed the defendant entering the passenger side of the complaining witness's vehicle, removing items and getting into another car. And I apologize, Your Honor, it said the wrong date in the summary, but it's 2022.
So that is because I was, okay. Did they get the property back?
We haven't made any meaningful contact.
Okay. Now, can we go ahead on the other case? Do you mind?
Officers conducted a traffic stop in Harris County, Texas, because the vehicle had a headlight out. The officer asked the driver for consent to search the vehicle. Consent was given. While searching the vehicle, the officer located a black purse that belonged to the defendant, who was the passenger of the vehicle.
That was
The
filthy
officer
animal
asked the defendant for
behind.
consent to search the purse, and the defendant gave consent. Upon searching the purse, the officer located a Rexall pill bottle that contained 2 white pills that had the imprint of M3.
That's not Will, guys. That's Connor.
67 on it. The officer, from his training and experience, identified the pill as hydrocodone pills and detained the defendant, and the total weight was 1.3 grams.
And I'm going to find that there's probable cause to go forward with both of your cases. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication, and not to have any contact with the complaining witnesses in the burglary case. Do you understand your conditions? If you violate these conditions, if you consume alcohol or dope, I'm going to put you in jail. If you show me that you can't stop, I will put you in a rehab facility. Do you understand? So you can either do it your way. If that doesn't work, we will do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Just for reference, what is the name of the complaining witness? In the
His name is
James Whitehouse.
James Whitehouse.
So Tracy, if you can do the conditions on the burglary case, please. No weapons, no alcohol, no drugs, no contact with the complaining witness. Ms. Robbins, it is your responsibility to stay in touch with Connor. He will tell you when you have court. I'm not going to put up with any flight. You take off on us and don't show up again, you will be, I'm going to revoke your bond. You will not get any more PR bonds. You understand, man? The only thing we're asking you to do is come back and stay out of trouble and don't use anything you're not supposed to use. All right. For now, I'm going to have you go to Victoria. We'll have you sign a reset, and then you'll meet with Tracy for your bond conditions. All right. Thanks, Connor.
Page 24, state.
Mr. Sager. Yes. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On July 7th, 2024, at 1:25 a.m., officers responded to a minor accident call for service and met with a complaining witness who was stopped on one of the eastbound main lanes of the East Freeway. As the complaining witness was stopped, the defendant struck her from the rear on the left side of her vehicle. The complaining witness advised she saw the defendant drive and he was the sole occupant, and she saw him exit the driver's side door. Complaining witness advised that the defendant began to apologize to her, and during the conversation he mentioned he was intoxicated. She recorded a voice memo of this. Officers observed the defendant to have a strong odor of alcohol on the breath, wet red eyes, and refused to answer any questions or participate in the standardized field sobriety test. The IC was read, blood warrant was obtained, and blood was drawn.
See if he has any prior to the eyes, please.
Yes.
Sager. Great. Mr. Sager, I'm going to find that there's probable cause to go forward with your case.
Thank you,
have valid
Logan.
Liability insurance in your name. Okay, as long as you have that and a license, you can drive. No more alcohol, no more dope. I'm going to randomly test you. If I find that you're consuming either, I will put you in jail. No more PR bonds for you. We're going to reset your case to give you time to hire a lawyer. So I'm going to first have you come up to Victoria.
Trinidaddy. Hi,
After that, you'll eventually get
Trinidaddy.
restricted with bond conditions, and after that, you're free to go. Don't pick up any new cases. Don't drive unless you have a license and insurance, and above all else, no alcohol, no dope. You understand? Okay, come on.
All right, Judge, page 28, Wazer.
Good morning, Mr. Slater. Sir, you're charged with two cases. You're charged with possession of marijuana and unlawful carrying of a weapon while intoxicated. You're facing up to a year in jail on the intoxication case, and you're facing up to 6 months in jail on the weed case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be.
Thank you,
used against
Donald.
You have the
Thank
right to have an
you.
attorney present. If you're not afforded one will be appointed to you, sir.
On July 5th, 2024, officers conducted a traffic stop for an expired registration sticker. The vehicle was slow rolled until it came to a parking lot of the Shell gas station. Upon contact, officers smelled the odor of marijuana and gray smoke emit from the vehicle. The defendant was the driver. A probable cause search located a black Ruger pistol behind where the radio screen is, and the gun was loaded with a bullet in the chamber. And a small storage bin under the steering wheel was 13.37.
You're never
grams
guilty,
of
ever.
marijuana in a saran wrapped bag. And the defendant admitted to owning the pistol, but said he did not know there was marijuana because it's his girl's car.
He's driving? So you charge him with unlawful carrying of a
Thank
weapon
you,
while
legal.
intoxicated, but he's not charged
50.
with the DWI. And
50.
he's charged with the weed.
50. Holy cow.
What's the sense in that? Hey, did you see this? Look at Swayzer. It's okay. He's in a car. He's driving. They charge him possession of marijuana. They charge him with unlawful carrying of a weapon while intoxicated, but it's not a DWI. I don't understand. I mean, how do we get to the intoxication?
I think today is
Tell me how they
nerds.
find intoxication.
No. It's gummy bears. Gummy lifesavers.
Standardized
That's
field
what's
sobriety
eating.
test.
Gummy lifesavers today.
So
Judge, we charge him with the UCW while possessing marijuana. If you look at the charging instrument, it's just straight UCW. We didn't charge him. I know it's titled that in the thing, but if you look at the charging instrument, it's just showing CW.
Because it shows here while
Yeah,
intoxicated, so.
it's showing like that on my end, but the charging instrument itself is straight UCW. That should know.
I don't think you have to retest, but I'm not 100% sure.
Is deeds down for you? Can you pull up the charging instrument? Because I can't pull it up here on Swayze. On the intoxication. Like, if you pull up the information.
Let's speed this along just a tad. Hi, Cindy. One more tad. Oh, we missed the whole thing.
Overcharge you. So for now, just take
Good
a seat
enough.
near the juror box. When I get it working again, I'll pull you back out. It's okay.
There's one seat left in there, but.
Okay. Yeah, I want to make sure that it's not, because I can't pull anything up.
We told Victoria to go fix it, and she said no. Victoria, go fix it. She said no. I'm gonna bump it forward a bit.
Lawfully, intentionally.
He's
and
back.
I'll read this to you now. It says, the defendant heretofore on or about July 5th, 2024, did then and there unlawfully, intentionally, and knowingly carry on and about the person a handgun in a motor vehicle under the control of the defendant, and the defendant was engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic, namely possession of marijuana. So that's what the charge was for. Okay, so I just wanted to make sure that it was an intoxication because they didn't give me any indication or any kind of evidence of intoxication. Otherwise, I would have found a probable cause. So being that as it is, I will find probable cause on both of your cases now. Tell me, do you have a Texas driver license, Mr. Swayze? Then you're not allowed to drive. And I'm making that now a condition of your bond. You will be signing an affidavit with me today, promising me you're not going to drive. I don't care what's going on in your life. I don't care what you're doing, where you're going, what you have to haul, what baby needs saving. If you don't have a license and liability insurance, do not drive. Do you understand? We're going to reset your case to give you time to hire a lawyer. So I'm going to first have you come up here, swear to us that you're not going to drive. Hold on. After that, I will get you to Victoria. We're going to have you sign a reset. When you come back, please have a lawyer, sir.
All right, Judge, page 22, Torres.
This is Betania Torres.
Yes.
Ms. Torres, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
On August 3rd, 2021, officers were dispatched to a single vehicle crash. The defendant stated to the officers that she was driving the vehicle at the time of the crash. Officers observed a strong odor of alcohol, slurred speech, glossy eyes, and the defendant appeared unsteady on her feet. Standard field sobriety test was conducted, 6 of 6 on BHGN, 7 of 8 on the walk and turn, and 4 of 4 on the one leg stand. The IC was read and breath was a .186 and a .189.
Now, she was in another county on another DWI, right? How many DWIs does Ms. Torres have?
I have that this is her first, but
That's not right, because she had another DWI. Or was she in a PTI with this case? Is that what it was?
This case was she was a DWI.
And I have that Eric Garza is representing her, is that right?
I sent him an email yesterday to ask if he was still representing her. I didn't get a response.
Okay, ma'am, I'm gonna find that there's probable cause to go forward with the case. I'm ordering you to obtain a handheld interlock device that you're gonna take with you everywhere you go to prove to me that you're not consuming alcohol. Do you understand? Yes or no? And I'm gonna tell you now, if you ever take off on me again, I'm going to triple the bond. We have tried to get you here over and over, over and over and over and over and over. That's why your bond is at 15,005. You miss court again, I will triple, if not quadruple. Do you understand? Take a seat. I need her to take a seat somewhere so I can find out what we're gonna do with the lawyer situation. So take a seat for me there. Do not leave, man.
All right, Judge.
Your Honor, on that case, there was an attorney that talked to me earlier, but I don't know.
Was that Fleming? Who was it? Or
I'm
no?
not sure, to be honest. But I believe she may have an attorney because he spoke to me.
Right, that's what we're waiting on. Take a seat. Do not leave, ma'am. Come back.
Bye-bye. She's not coming back.
Okay. John D.
I don't know if she comes back. I don't remember.
Just want to talk to you about 3 cases. 2 are on the docket today. And 1 is a trial case next week. Today, we have
Trial
Miss
next week.
Montera Robinson, which I don't know if you remember, but she was the one that we pulled teeth to get her on the PTI program. And last week, there was a notification that she's been kicked out of the program for non-compliance. The courts put her on the docket for today. Every contact information that I have with her is no longer. I tried to get her here. She's obviously not here, Judge, so.
It's okay. I'll set it at 5,001.
Okay.
What's next?
The next one is a late appointment yesterday, Mr. Sorrell, S-O, he was in custody yesterday. We rolled him over to today, but he's out, so I guess, I don't know if he's gonna make it here, but.
No, from what we
The
understand.
capias?
Paid the
He
capias.
paid it? Okay,
Paid
so
it.
good deal.
That, you verified that he paid?
He was released and the release reason said paid fine.
Okay, so that's over.
And then lastly, Judge, the trial case that was postponed to next Tuesday, Mr. Eric Sukwu, I finally chased
Hi,
him down,
Logan.
and we'll be pleading out to a time serve on that. The only malfunction is I can't get him here on Monday because I'm out of county, so we got to do it Tuesday morning. I have to be, I'm trial setting down in Fort Lynch. So we'll take care of that on Tuesday morning. Just want to give you a heads up on that.
Okay, thanks, John.
Thank you, Your Honor.
Sure, thanks. Mr. Slider.
Judge, how are you?
Okay.
Here on Angel Jackson, it's a bond violation.
Ms. Jackson.
She's in the fuchsia or the.
Ms. Jackson,
Page 9.
come up.
I hate when they steal my clothes for court. Just makes me
Good morning,
really
sir.
mad.
I'm not happy with you, Ms. Jackson. You have bond violation after bond violation after bond violation. You were ordered not to consume alcohol. You were ordered to get a device and blow into the device, and you're trying to fool us. What's this look of bewilderment that you have? Mr. Slider?
Judge, I met with Ms. Jackson yesterday. She's acknowledged that she made a few mistakes. Wants court to give her another chance. Says she will comply with the rules of the monitoring.
Her
device.
attitude tells me something completely different.
Let her just tell you directly.
No, sir. I think what I explained to my attorney yesterday is I believe that I may have a problem and I didn't get the opportunity to get any additional support. I acknowledge that.
So something has to change because what we're doing now is not working.
Yes, sir.
So what has to change? What are we going to do?
I need support. I need to go to some type of meetings in order to help me with my urges, honestly. I'm a single mother. I do things. I recently just moved. I've been trying to grow in my life, and in that I've been stressed a little bit, and that's what's causing me to consume.
How many kids you got?
I have one child.
How old is that child?
He's 9.
I see that child.
Me, full custody.
What happens if you go to jail?
His father would take him. I don't think he would like that, though.
Well, let me ask you this. Do you get along with the father?
I do.
Do you have a custody support arrangement or
So
what?
we just co-parent.
She's a single mother who co-parents.
No, it's not going to start. It's going to happen. And I want 90 AAs in 90 days. And I'm going to bring you back in 2 weeks. And I want to see that you've got 14 done. And if you don't have it done, guess what's going to happen? Correct. And I'm now modifying your conditions. I'm giving you 1 day and I'm going to put an ankle monitor on you so I know that you're not consuming alcohol. I'm going to modify the condition to put a scram on her ankle so I know that she's not trying to fool us again. Ms.
She'll turn in
Jackson.
the current blow device and put the scram on.
Correct. If
Court
you
paid for
fool me
that.
one more time, if you try to play me for a fool, you will go to jail. I will not give you any more chances. The only way that you will remain out now is if you're doing AA classes on a daily basis to prove to me that you're trying to take a proactive approach to staying sober. But the next time you will go to jail, I will hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a rehab facility. And I'll do it in a heartbeat. Do you understand, Ms. Jackson?
Yes, sir.
That's what you have waiting for you. And I don't care where you come up here and try to say where the alcohol came from. I don't care if it's a tequila lollipop, a buccal swab. I don't care if it's isopropyl, hair dye. I've heard it all, and I will not entertain any excuses from you. Mouthwash, I don't care. Do you understand?
Yes, sir.
So let's reset this thing 2 weeks from today. She has 1 day to get these, or she has until Monday to get the scram device on her ankle.
The court will pay for that, Judge.
Of course.
Thank you.
Thank you, Your Honor.
Can you excuse, Judge?
Sure.
Thank you.
Judge, real quick on waiting period. I saw you said no driving affidavits, but did you say bond conditions or
No,
none?
no, just no driving and then get them out for THA.
May I approach on?
Yes, but let me just, I have to,
Hey, Judge, I'm here for Mr. Blunt.
is Mr. Blunt here?
Yeah.
Mr. Blunt, come on up.
And I'm actually out of town
Oh.
on vacation this week. I'm at scout camp with my son. I didn't want to get on video if that's okay. Pretty horrific.
It's okay, Harold. So what's going on with you, Mr. Blunt?
How you doing, Judge? I couldn't make it because I had to go back to the doctor to get some x-rays.
I'm saying no. Everybody was saying that this was the soft sit, but it's not the soft sit. The soft sit was like, his name was not Blunt. What was his name? It was like Westerdale. Just kidding. But it was something like that. This guy wasn't, I mean, I know he looks like him. I understand that he looks the same, but I'm like positive that the soft sit's name wasn't Mr. Blunt, was it? Was this guy the soft sit? He doesn't say anything bad here.
Well, from a cousin or whatever it is that they say that happened, and they told me to come back in today.
Proof that you got that you were there.
I gave it.
Okay, I'll take a look at it. We are still down. We're not allowed to drug test people. So what we're gonna do is I'm gonna bring you back next week and we're gonna test you. Don't use. You understand? All right, just go ahead and take a seat. Be back with you shortly. Harold.
Yes,
we'll be
sir.
Back one day next week to test.
Okay, can we make it either Monday or Tuesday, Judge?
Yeah, for sure. Whatever you want.
Okay.
You want Tuesday?
Tuesday would be great, because then on Monday's gonna be pretty crazy for you.
Yeah, it's yours.
Yes, sir.
Okay, thanks, bud.
All right, thank you, Judge. Appreciate it. Y'all have a great day.
You too. Take care.
All right, bye-bye.
There's Carl
Will.
over there looking Texan. Hey guys, it's Will. It's Will and Ramona.
Hey, Judge.
Hey, bud.
Okay, so we're set on these 2 cases for trial on Tuesday.
Okay.
I've talked to the state about them. I think we're 3rd and 4th up. Just wanted to let you know that.
Are you ready on both cases?
Tompkins is like 9 days older than Chua. Definitely ready on Tompkins. Chua, we may have a continuance, but I'm really not sure at this point.
How come you're not sure?
Because it's a witness issue. I
Okay.
can't lock this guy down. So
Have you had a continuance yet?
no.
Okay, so you only get one bite of the apple, as you know. Okay.
That's why
If
I
you
don't
want
want
it-
to.
If you want it, you can have it, but you only get one. So
He doesn't want to burn it. Maybe Tompkins can go first, and he doesn't have to burn it. It just gets reset.
I understand.
Yeah, I think that's where we're getting at here.
Understand, but really, I don't know. Are you ready on both?
Yes. So Chua, we offered PTI and time served. I think the issue with the PTI was the restitution, obviously.
Rude.
So that's why I offered time served.
Absolutely
It's
rude.
king of a car.
Mean
So
even.
the restitution amount was 2,500. We had proof of it and everything, but it's a big amount. So,
And I'm gonna tell you now, if they're found guilty, I will do everything in my power to get the restitution until it gets paid. And if that means jail after jail after jail.
I believe he knows that already. I mean, this has been an ongoing conversation for months now. With Tompkins, well, we're also ready. It's just a donuts case. I mean, donuts in the parking lot.
I'm gonna try that.
He's well, there's a defensive theory there, so.
Oh, is this the one? I think you guys, was it some kind of necessity or something?
No, no. No, he's not doing donuts out of necessity. It's a ID issue if it were to go to trial.
Okay.
Yeah.
I don't know. Will, you tell me. I mean, I'm happy to do whatever you want to do. Just at this point, we're in a holding pattern. Who's 1 and 2?
One is Roku, because that was a 2022 DWI.
That's where I know.
John Dung. We already spoke, and I believe
You say he's gonna plead?
Yes, I don't want to ex parte anything, but he already approached earlier today on that one. And then 2, I forgot who was number 2.
It's 2, Logan.
Who's next up?
And it's properly dismissed and
Hello, Miss Ramona.
I'm not sure.
Contreras Martinez, the other two, Your Honor.
Oh, yeah, Martinez is older, so that would be, that's with Flood. Until Flood approaches, I don't really want to talk about that case.
Okay,
So.
let me.
But yeah, for his case, I mean, one's gonna,
Tyler's case, Tyler Flood?
one of them is, yes,
Yes, Martinez is.
Martinez.
Okay, let's talk to them and then I'll call Tyler and we'll figure out if they're ready as
Sure.
well.
Okay, but yeah, with regards to his two cases, I mean, I understand why he doesn't want to burn his continuance yet,
Yeah,
but
you might be up.
he's
Yes.
3 and 4.
This is Pavel,
All right,
Ramona,
Tyler said.
Will, Judge Fleischer.
I don't
You
know.
know tomorrow's going to trial,
When we
Judge.
come
You know
back-
that.
I
come
can't
back
remember her
later, if
name,
you
I'm
want, maybe
sorry.
in like half an hour, we can talk more.
Logan,
Okay, sounds good, Judge.
Tracy.
Okay, Amy. Hi.
Bye, Ramona.
Sure.
251-8462.
And that's Carl. Bye, Carl. We'll get to Carl some other day. And we'll get to Filthy Animal with Carl was with Filthy Animal, right? Like I just stopped at one case early, didn't I? We would have seen Filthy Animal. But it's fine. We're still going to get to see them. Don't worry. I had to end on Will and Ramona because I had to. Okay, guys, we did a lot of court today. Wow, it was exactly 2 hours when I first started saying that, and then it flipped over to 2:01. So now I'm just a liar. I'm just sitting here lying to my team, to my monitor. My monitor. Her name is Elise. That is right. That is right. You're right, Spade. You got that. Yes, we're all with Filthy Animal. I can't remember what his crimes were, so I'm guessing DUI. That's my guess. And, 50% of the people here do DUI, so I have a 50% chance. Ooh. I also have 100% chance of getting comments today to tell me how I'm wrong. Carolyn, I don't need Google. I never need Google anymore. All I do is say something and wait. And then boom, my comments are full of the correct answer. And I can get controversial. Like, did you know that clouds are made of ice? I'm going to get comments on that one. Yeah, I am. Some people are going to say, well, yes, there's ice particle in clouds. And other people will say, well, it doesn't matter. Yep, you guys are smart. You know what colors are, Hope. You're a color wheel expert. Oh, there's no more videos today. Bye, whoever's here to watch videos. Goodbye. Have a good day. Nice to see you. Water is wet. Oh, gosh. Oh, I didn't want to say that one. Metal. By misconduct. Sue. You too. Clouds are made of cotton. Duh. No, they're fairy floss. She's not even here, guys. Who was it? It was Amanda Panda. She doesn't like the word moist. I don't think anybody here cares. Moist. She had a problem with that today. But then again, she kept bringing it up herself. So I guess you really have a problem with it. Maybe we'll get to see Will come into court tomorrow. Maybe not. Oh, no, he won't because there's no court tomorrow. I am absolutely not singing. What am I singing anyway? I didn't even hear a song. Was there a song? Moist, moist, moist. That's not a song. No. Yeah, legal. You were the lead troller. You were ahead of everybody. Every time she put her guard down a little bit, boom, you ran in there with a moist. A moist slapped her right upside her head. Edward, I'm going to sleep too. I can't wait. I got the best band coming in tonight. I'm going to put clips of it on my Discord because I have the best band coming in tonight. So I need to get some sleep so that I'm ready. You were Captain Moist. You sure were, sir. I think security, you were up there too. Yes, security, I'll come into Discord. But yeah, it was a great time in Judge Fleischer's chat today, guys. It really was. Maybe I'll see you guys there Monday. Maybe I'll see you here in 22 hours when I do my next stream of something that I don't have yet. But don't worry, I'm going to get stuff. I'm going to get stuff. Anyway, you can still go to sleep at 11:30 a.m. Ain't nothing stopping you. You're fine. Go to bed. Go to bed. Yes, dueling accordions. Oh, no, it's actually a real band tonight. A real great band tonight. I can't wait. I mean, I feel like I'm going to a concert tonight, even though I'm going to work. I'm glad you had fun. I love this chat. We were actually very tame tonight for some reason, and I don't know why, and that's fun. Yes, it's the weekend and people are tired from working all week. Maybe I need to reread that dumpster fire case. Joking. I'm joking. I'm joking. I'm not going to. Maybe. I mean, he does have a motion that I put in Discord. I could read that. Just kidding. Just kidding. Thanks for coming out, guys. Legal, you do not have to gift any more memberships. You just don't have to. They'll come. They'll come. If I build it, they will come, they said. I saw it. It's a movie. So it's true. Thank you for everybody's support tonight. I really, really, really appreciate it. Misconduct, thank you again. Fozzie, thank you again. Donald, you're never guilty, but thank you. And Legal, 50. Woohoo! Thank you. I will see you guys in my Discord. Come over to my Discord. Bye, guys. Thanks.
you.